SJC-12371, Commonwealth v. Amelia Escobar.
Mr. Crane, good morning.
Good morning. May it please the court, Edward Crane on behalf of Amelia Escobar. The issue in this case is the scope of the term anything of value in the identity fraud statute and whether it covers the avoidance of a criminal charge. It's the defendant's position that the term should be limited to those things with legally marketable or exchangeable value. The principle of a justum generis supports this definition. A justum generis is a principle of statutory construction that limits the scope of a general term that follows a list of specific terms to things that are similar to those specified terms. Applying this principle here, the term anything of value must be limited to things that are similar to money, credit, goods, or services. All of these specified terms have some sort of legal marketable or exchangeable value. Avoiding a criminal charge does not.
What if it's avoiding a criminal fine?
Again, I don't think it has it involves money, but it is not something that can be legally exchanged. It couldn't be legally exchanged as consideration in a contractual agreement. I think the rule of lenity is another consideration here. Under this rule, any plausible ambiguity in a criminal statute has to be construed in favor of the defendant. Here, I think the term anything of value is certainly ambiguous, as reasonable people could certainly disagree about the scope of the term. The Commonwealth argues that the term is plainly worded, but the Commonwealth itself cannot come up with a definition for the term other than simply restating it, the term itself.
Can we go back to legislative intent? So this statute was enacted, I guess, at the same time as the false name statute, giving a false name following an arrest.
Yes.
Is there any legislative history as to why the legislature chose to limit giving a false name to only following an arrest as opposed to before an arrest? Clearly chose to do that.
No, I have not been able to find any legislative history as to why the legislature did that, and really the only conclusion that I think that can be drawn from the fact that that statute was put in place at the same time as the identity fraud statutes, we can certainly discern that, look, the legislature knew how to punish the act of giving a false name to a police officer, whether it was before or after arrest. And I think that we, not knowing anymore, I think we have to conclude that the legislature made a conscious decision to punish solely giving a false name after arrest. Why they did that, I don't know.
Well, let me ask you. Let's assume there's a stop on the street. A police officer, for whatever reason, doesn't need reasonable suspicion, stops me and says, "Hello, tell me your name." And I say, "My name is John Doe." Not a crime under Section 25, because I've not been arrested, correct?
Well, I think sorry, there are three statutes. I think 34A is the one that, 268-34A applies to giving a false name after arrest.
Okay, and then the other is operating a motor vehicle, and I would not operating a motor vehicle. I'm on the street.
Yes.
So police officer can say, "Hi, tell me your name and where you live," and I can say, "John Doe." Not a crime.
Not a crime under either one of those statutes, no.
But if it's a thing of value, if there is a warrant for my arrest, then I've committed a crime under 266, Section 37EB, if anything of value would be enough to do that?
Well, I don't think so, and I think that gets closer to certainly the facts of this case. I don't think that, Well, first off, I don't think that giving the name John Doe is necessarily personal identifying information in this case, because that would not be, I think the identity fraud statute really relates to giving a real person's identifying
I say I'm Donald Trump,
Okay, okay.
which I might be. So I've given a real name,
Yep.
clearly a false name.
And I think in that situation, the thing of value would be, I guess, avoiding the arrest warrant. And I don't think that under the way that this statute's written, that avoiding the arrest in that situation would qualify as anything of value. And again, I go back to that principle of a justum generis and the rule of lenity.
Even if the chief had 10 parking tickets that he's avoiding paying?
Yes, I think that,
Well, I understand we don't get to the interpretation if the language is clear, but Judge Fiandaca, I think, cites to a number of cases to say that anything of value has become a term of art. The United States versus Petrovac case, I think it is, and
Yes.
maybe I can't remember the other United States Court of Appeals, and if it really is a term of art and that it's easy to understand, plain to understand for the average person, that it's something of value to avoid getting arrested for something serious that you've done, why isn't he wrong about that?
well, I think that, well, first off, referring to it as a term of art, I'm not quite sure if that means that it's unambiguous. And I think with respect to those, I think there's an important distinction that has to be made with respect to those federal cases, Petrovic and the other cases that are cited not only in Judge Fiandaca's opinion, but also Commonwealth's opinion, Commonwealth's brief. Those cases all involve statutory language that leave this term anything of value. It's not connected to any other specific terms. That principle of the justum generis is not applicable in those situations. I believe that in 3 of those cases, it involves an extortion statute that simply states money or anything else of value. And I think certainly in that situation where you just have money or anything else of value, you can interpret anything of value much more broadly because that principle of a justum generis is not applicable. And then in the other 2 cases, it's simply anything of value. And I think that's a federal bribery statute. And so again, obviously, that principle of a justum generis is not applicable there where it's just the term anything of value standing alone. That term, and I would argue that those cases are rightly decided because that term anything of value standing alone can certainly be given a broad interpretation, unlike the situation here. And I think the case that really is most applicable to the situation that we have here is People v. Beck from Colorado, because that statutory language is almost identical to the statutory language employed here, and the principle of a justum generis was applicable and was applied. And I think that rationale is directly applicable here. And I think that's...
But doesn't the Colorado, there's a statute that defines anything of value there, which we don't
Yes.
have, right? That makes it our case.
There is, I think that the rationale of People v. Beck was not overruled. So People v. Beck was overruled to the extent that the court did not apply a universal definition that was written out in the Colorado Criminal Code that defines thing of value.
But there are federal cases, too, that say that intangible things can be things of value. Why would that not be more applicable here where we don't have the limiting language that Colorado did in its statute?
Well, I think those federal cases are cases that involve the term anything of value, again, where it is not connected to any specific terms other than money in the extortion statute, and then in the bribery statutes, it's simply anything of value alone. That's why I believe in those federal cases, you can interpret anything of value quite broadly. I think anything of value in statutory language, if it just comes down to, if you do this to acquire anything of value, then it's quite proper, it's absolutely proper to interpret anything of value very broadly. There's no limitation on how to interpret that term. Here we have, and again in that Beck case, in the Colorado statute, we have these other specific terms that are listed prior to anything of value that I think, under the principle of a justum generis, must be, must limit the scope of anything of value. And just with respect, again, to that Colorado case, the universal definition of anything of value in Colorado is written out, but it does not. The decision that overruled that portion of Beck does not get down to whether anything of value, the way the statute's written in Colorado, which is the way the statute's written here, whether the principle of a justum generis would be applicable. It simply states that the universal definition should have been applied, and I think it does not overrule the overall conclusion in the Beck case, which is that anything of value does not include the use of someone else's driving record. I think even if you were to look at the Molina case, which overruled Beck, even if you applied the universal definition that the Molina case says is applicable, it would not encompass the use of someone else's driving record. But that's something for the Colorado Supreme Court to consider, not this court.
Now, the United States Supreme Court, with regard to the mail fraud statute, was dealing with a statute which makes it a crime to devise any scheme or artifice to defraud or for obtaining money or property by means of false or fraudulent pretenses. Prosecutors in the 80s, including me, were prosecuting mail fraud under the first part of it, any scheme or artifice to defraud, based on a scheme to defraud the public of the right to honest services. Supreme Court in McNally says, no, you can't do that. There has to be money or property. Then Congress later revised the mail fraud statute expressly to permit a scheme to defraud the public of a right to honest services. Is there an analogy here to what the Supreme Court did in McNally?
I think in the sense that, so what were the terms at issue in McNally? What's the statutory language at issue?
There were two phrases in the mail fraud statute. Any scheme or artifice to defraud, and that was the one used by public corruption prosecutors, or for obtaining money or property by means of false or fraudulent pretenses. And they said, okay, well, there are two clauses. We're going to focus on the first clause. The first clause is not limited to money or property, so we're going to say it's a scheme or artifice to defraud the public of the right to honest services. Mm-hmm. And McNally, your Supreme Court says, no, you can't do that. You've got to have money or property.
Yes, I think it would be more. I guess it would be more applicable if the terms had been listed: money, property, or honest services. I think in that situation, it's more akin to the statutory language at issue here. But I do think that. No, I think that would be a comparable statutory construction. I think. I guess the way we could compare it to this case, and maybe to some of those federal cases we've already discussed, is honest services. I think standing alone would encompass lots of things if it didn't have that separate money or property aspect of the statute. But honest services, just like anything of value, those two terms standing alone, I think could encompass many things. Yet those terms, when combined with more specific terms that precede it, they have to be given a limited interpretation.
All right, thank you.
Thank you.
Ms. Kesselheim, good morning. Kesselheim.
Good morning, Your Honors. May it please the Court. Assistant District Attorney Dara Kesselheim on behalf of the Commonwealth. The Commonwealth respectfully requests that the Court affirm the order denying the defendant's motion to vacate her admission to sufficient facts. The key question on appeal is whether the defendant's conduct in this case amounted to a violation of the identity fraud statute, and it did. I would direct the court's attention to Commonwealth versus Nye, 2017. It's an unpublished decision by the appeals court, 2017 Mass Unpublished Lexus 176. It's February 22nd, 2017 case. Unfortunately, I found it after my brief was filed here, but have submitted the citation to the clerk and to my brother by way of a 16L letter. And in that case, the appeals court looked at a similar question, that is, whether presenting somebody else's personal identifying information after a traffic stop to avoid, to be able to drive a car while the defendant's license was suspended was something of value under the identity fraud statute, and the court concluded that it was. The court found that the defendant's ability, the thing of value that the defendant sought to obtain by presenting another person's stolen driver's license information was her ability to drive despite her license being suspended. And the court concluded that that, quote, certainly qualifies as something of value. And the Commonwealth would suggest that that's precisely correct here. The defendant in this case sought to obtain multiple things of value. She sought to avoid possible arrest or criminal charges, that is, operating after a suspended license. She sought to obtain the ability to drive without a license, the benefit of her freedom, possibly.
Counsel? Hi. So I don't think that he contends that it's not something of value, but I think he's saying that it doesn't fall under the statute. So what about the statutory construction argument that the justem generis argument that he presented?
There's no need for the court to resort to principles of statutory construction where the terms of the statute are clear. And in this case, the term anything of value is clear. That's in keeping with the long list of cases cited in the Commonwealth's brief, in which, as the motion judge recognized, the term thing of value has become a term of art in these kinds of statutes. And it encompasses both tangible and intangible things. Now, if the legislature had intended to limit the term, the terms of the statute to items of marketable value, as my brother suggests, they could have done something similar to what the Colorado legislature did in defining the term thing of value to limit it to terms of marketable value. That's not what they did here. They deliberately kept it to be intentionally broad. I would direct the court's attention to Commonwealth or United States versus Petrovic 701 F3rd at 858, which says these cases, citing a bunch of cases in which thing of value is interpreted to include both tangible and intangible things, reflect the principle that value is a subjective rather than objective concept, where the focus of the term is to be placed on the value which the defendant subjectively attaches to what is sought to be received. I'd also direct the court's attention to United States versus Nilsen, 967 F. 2nd 539. It's an 11th Circuit case from 1992, where the court held that the testimony of a witness was a thing of value that could be extorted.
So if you're right, why did the legislature, in enacting that same statute as part of the same law, limit the crime of false name following, the crime of giving a false name to a police officer to only following an arrest? If you're right, they effectively made it a crime to give a false name to a police officer before an arrest, because anything of value was almost always going to be satisfied. Why would they have done that?
To limit providing a false name.
They limited that to following an arrest. You are effectively saying, well, it's a crime to give a false name before an arrest to a police officer, and actually it's a much more serious crime. So it's now identity theft. It's also going to be for purpose of immigration. It is going to be viewed as a crime of, what's the term? Moral turpitude. So you're saying the legislature intended to make what it did not do in Section 34A, that it meant to do it in 37EB and meant it to be a much more serious crime with much more serious consequences. Why would it do that?
Because it is a more serious crime, Your Honor. In one case, providing a false name to an officer after an arrest may have a consequence only to you, or to the office, to the government and to the defendant. So it might take longer for the government to figure out who this person actually is, that kind of thing. With identity theft, there's a serious impact on the person whose identity has been stolen. So in this case, charges could have been taken out against Ana Escobar for operating after a suspended license, the person whose identity she stole.
I don't get that. So I arrest somebody and I say, my name is Ana Escobar. So the complaint will say Ana Escobar. If the person says, who are you, and I say Ana Escobar, and then I'm placed under arrest, it's this very same consequence.
But she might not have been arrested. Had this played out the way the defendant hoped for it to play out, she might not have been. If Ana Escobar's license had not been suspended, the defendant might very well have gone on her way.
Okay.
In that case, there would be consequence to Ana Escobar because there would still be the civil infractions that resulted from the traffic stop and from not having her license on her at the time of the stop. But the defendant isn't actually arrested. In the case where the defendant is arrested and she provides a false name, that's a different kind of penalty. That's a different kind of violation.
Meaning it's more serious because she could have gotten away with it, and that's why the identity fraud statute has more serious penalties?
Right, to the detriment of somebody else, having fines or charges taken out against someone else to have no consequence.
The other person can get fined. Escobar can be vulnerable even after an arrest because they could let you go and then they go looking for the wrong person, right? I'm not sure why. It seems like it might be more serious because you may be able to evade arrest altogether under the first one, but
right. That's what. If I was unclear, that's what I'm saying. So if in fact Ana Escobar's license had not been suspended in this case, the defendant could have evaded arrest and could have continued to drive, even though she hadn't had a license issued to her. She could have continue to drive under the name Ana Escobar. So she'd be getting that benefit. And consequences of her using Ana Escobar's license would be to the detriment of Ana Escobar. Or say, in this case, if Ana Escobar had suffered an immigration consequence, if deportation proceedings had been initiated against her because now she has the second charge, erroneously, a second charge on her record, the consequences of stealing someone's identity to your own benefit and their detriment is exactly what this statute is designed to punish.
So let's go back to the immigration context. I'm an undocumented person. Police officer stops me. I don't want to give my true name because I'm worried about it. So I give a false name. I'm guilty now of identity theft?
Not a false name, Your Honor. If you misappropriate somebody else's identity and personal identifying information,
So
that's different.
I give a true name of somebody else, but it's not my name. Every time that happens, I'm now guilty of identity theft.
If you provide your name to an arresting officer,
Not an arresting officer. I'm just stopped in the street. Person stops me on the street, says, hello, would you please tell me your name? I don't want to give the person the name, so I give somebody else's name. I give my brother's name. Because he's a citizen and I'm not. So I've now committed identity theft and now I can be deported because I've now committed a deportable crime.
if you've done it, again, you'd have to fulfill the remainder of the statutory provisions, which I think insulate.
I posed as another person. I posed as my brother. I did it because I was worried.
Without his
Without his authorization, yes. He didn't say I could use his name. And anything of value, you're saying, oh, that could be to avoid the possibility of deportation proceedings. That's something of value,
If you weren't being arrested, if you weren't,
just being stopped. Now you're going to arrest me and say, you're not your brother. You're under arrest for identity fraud.
yes, if you provide, if you fulfill all of those statutory requirements and the thing that you are seeking to avoid is an immigration consequence, then yes, that is something of value.
Every time a undocumented immigrant gives a false name of another, they have committed this crime of identity theft.
Without that person's express authorization, with the intent to defraud, that is to trick or injure someone through artifice, yes, that would be identity fraud.
They have to be seeking something of value, though, right?
Correct.
So if they give someone a name and there's nothing of value associated with that.
That's right. I believe the Chief Justice's point is that you're avoiding immigration consequences. So if you are concerned about interacting, I think there would have to be some avoidance of a charge. If you knew that you were avoiding arrest for something, that would be the thing of value in that case.
I'm undocumented, so therefore I need to worry about the possibility of ICE seeking to do something to me.
Right. So then, yes, that's identity fraud. And again, I would direct the court's attention to the Commonwealth v. Nye, Commonwealth versus, United States versus Petrovic and United States.
Are there
versus-
any immigration cases? Because it sounds like this is now becoming an immigration case. So are there any immigration cases interpreting these identity fraud cases that you're aware of?
I found one unpublished case in a Kansas unpublished case. It's a Commonwealth versus Martinez-Perez, 2014, Kansas Appeals Court unpublished, Lexus 415.
Sorry, could you give us that site?
Yes, 2014, Kansas Appellate unpublished, Lexus 415. It's again, Martinez-Perez is the defendant's name.
And did they find it was a thing of value? Did they do, how did they analyze this?
They analyzed it. So in that case, the defendant was stopped for a traffic violation and said he didn't have a license. He provided the name of someone else, and while he was getting his license out, the officer saw a license issued to somebody in a different name in his wallet. And then the number on that license was actually assigned to an actual person with a different name. And he was convicted of identity theft. And he challenged his conviction, arguing that the state had failed to prove that he had an intent to defraud a person that person to receive any benefit. The word they used was benefit. And the court upheld the conviction and found that there was ample evidence that the defendant intended to defraud the officer by leading him to believe that he was Francisco Sotelo so that he would not suffer the consequences of being found to have a previous DUI conviction and being found to be in the country illegally. And that was sort of the closest I could find to an immigration case in the identity fraud context.
I mean, you agree that a crime of moral turpitude is automatic deportation, or as close as there is to automatic deportation.
My understanding of the immigration law is somewhat limited. I know that I thought it was one conviction would be denial of reentry, and it would take 2 crimes of moral turpitude for deportation. But I would have to revisit that issue.
Applying the Chief's questions to the other 2 statutes for a second. Chapter 90, Section 25. So he refuses to submit to any person who, while operating or in charge of a motor vehicle, shall refuse when requested by a police officer to give his name or address, or the name and address of the owner of such motor vehicle, or shall give a false name or address, shall be punished. So I take it, if you use that hypothetical, they're going to violate that provision, right? If an immigrant gives a false name to a police officer, they're going to violate that one. Would that be Is that a crime of moral turpitude too?
I don't know, and that was something that, I'm not sure under the immigration statute whether that is a crime of moral turpitude. I know that at the motion to vacate the plea, that was something that my brother was also uncertain of at that point.
Right, but the maximum penalty for that, according to Section 25, is a $100 fine.
Yes, but again, that it's a much...
There's no jail option.
Yes, but that's a much less egregious violation because you're providing a false name. In other words, that could be a made-up name, so that the consequence would, providing the false name would be detrimental to the cop and to the government, but it wouldn't be detrimental to another citizen who hasn't committed any wrong. So there wouldn't be a charge erroneously taken out against someone else, or possible criminal penalties or civil fines taken out against another person. So it's less egregious conduct.
What would you say about Ms. Escobar's argument that the federal cases, United States versus Petrovic and United States versus Nielsen, that they're really not applicable because the anything of value language is standalone language as opposed to language that's tied to tangible objects of value?
First of all, I think it's important to note that the defendant extracts, or my brother sort of extracts that term from the remainder of the statutory language. So it says, the way the statute reads in Massachusetts is obtain or attempt to obtain money, credit, goods, services, anything of value, any identification card or other evidence of a person's identity. So that string in which those terms that he terms are specific, number one, includes other terms that follow the term anything of value, and I don't think that's proper to do. I think the term has to be read in context of the full phrase. And second, I would argue, as the motion judge did below, that the terms that it does follow, so money, credit, goods, services, are not specific enough or similar enough that they would define or serve to limit that term anything of value. And I think to the contrary, they indicate that the legislature enumerates several things, but then intends for the phrase to be sufficiently broad that it would capture things that are of value to the defendant. In this case, the avoidance of criminal charges, the avoidance of immigration consequences. If I used my sister-in-law's identifying information, she's a doctor, and I used her identifying information to gain access to a hospital and attend grand rounds or attend a procedure, that's identity fraud. You can't put a specific monetary marketable value on it, but that's something of value to me that I am misappropriating somebody's personal identifying information in order to obtain.
The first part of your argument is that when you list the money, credit, goods, services, then you have anything of value. And then after anything of value, you have other terms such as identification card or another person's identity. So that's no longer just limited to these tangible objects, so that doesn't necessarily limit what anything of value means.
That's correct. Unless the court has further questions, the Commonwealth is content to rest on its brief.
All right, thank you. We'll take a morning break, I think.